Okay, and then finally, if there is a loss of juridical advantage or procedural advantage, then the court's got to try and balance that up and work out what is best in the substantial justice between the parties. I love the bit where the judge says the court must try to be objective, as we'll see, sometimes easier said than done. Right, so basically it's forum non-convenience is the main issue. The court will have to exercise its discretion whether to continue with the proceedings or whether to stay and release. And I've just thrown in a couple of other reasons why the court might stay or release. I won't go into those in any great detail. You may have a foreign jurisdictional arbitration clause in your bill of lading that might require you to proceed elsewhere. And then we'll come back to the limitation convention that says that if a fund is constituted overseas, you have to release vessels where you are. But there are some confusions with that. Right, so there we have a little bit of a collision. Were there any pressing questions before I go on? Have I lost everybody already? We're all good. All right, we'll plough into choice of law then. Yes? Sighs, grimaces, one or two smiles. Right, you're still alive, that's the main thing. Okay, so choice of law. The problem with any collision is that more than one legal system is competing to apply. It's not going to be like a local tort usually. There's going to be ships flying different flags. The collision is going to take place in a territory that may be totally unconnected with the ships. So you need to work out what legal system is going to apply once you've had the bun fight over which jurisdiction is going to apply. The starting point, unfortunately, for most common law jurisdictions is Phillips and Eyre, and I say unfortunately because it has to be the stupidest conflict of laws rule ever thought up by an English court. Basically, it's what we call the double actionability rule, which says that the tort must be, or there must be an actionable wrong in the lex fori, which is just a fancy Latin way of saying the law of the court where the case is heard. So in our examples, we're looking at say it's heard in Hong Kong. Hong Kong law would be the lex fori, and the lex loci delicti, the law of the place of the tort. Now you can immediately see the problem. This is designed for land-based torts. It's not a particularly sensible rule for torts that happen in the middle of the ocean. So that's the basic rule that's set out, but we have real problems when we apply it to maritime collisions. For a start, if the collision happens in territorial waters, which law do we apply? Do we apply the law of the ship's flag? Traditionally, we've seen ships as floating islands in conflict of laws, and if you're flying a New Zealand flag, then New Zealand law operates on your little ship. However, in a collision, unless you're very lucky, the ships will be flying different flags, so it simply doesn't work. So what they've tended to fall back on is the law of the littoral state rather than the littoral state. The littoral state, in other words, the law of whose territorial waters you're in. Now that at least is a practical solution, but of course the problem with it is that your presence in those territorial waters may be completely fortuitous. It's not like a contract, it's a tort. Nobody saw it coming, and it could have happened anywhere, and so it's completely fortuitous that you are in Hong Kong territorial waters, Indonesian territorial waters, but suddenly that legal system applies to the collision between you. But that's the best we've come up with so far in terms of Phillips and Eyre. It gets worse though. If the collision happens on the high seas, there is no lex loci delicti. There's a locus delicti, but there's no lex to apply. No legal system operates on the high seas. Now the English court solved that by saying, well, of course we knew that English maritime law is the law of the seas, so we'll just apply that. But over time, as they became less gung-ho, they had to admit that in fact all they were doing was applying the lex fori. And that really probably is the only solution you can come up with, because there is a vacuum on the high seas. What it means is the double actionability rule just becomes an application of the Lex Fori. The problem with that, of course, is it encourages forum shopping. Okay, now I've painted a pretty grim picture. It's actually not that bad. The reason I say that is there's been a lot of work in the international arena. We've got the Collisions Convention, we've got the Collisions Regulations, the so-called Rules of the Road. So pretty much everybody's singing from the same songbook. And I've given you the list for Hong Kong, but basically it's the same code for everybody. So if you had a collision in New Zealand territorial waters, the names of the statutes would change, but the contents would be pretty much the same. So in that sense, perhaps it doesn't matter too much whether we fuss about Lex Fori, Lex Loci Delicti in this context, because of the work of the IMO and various other international bodies. However, there's always a however, there are still gaps. So if we look, I just took a couple of statistics from the IMO website. Coal reg's doing very nicely, 98% coverage. So your chances are wherever you hit another vessel around the world, you're going to be dealing with it in terms of coal regs. The Bunkers Convention though, 88%. Limitation of liability for maritime claims, which is the important one we're going to look at after the break, the 1976 Convention, only 50%. Athens, personal injury to passengers, that's even worse, 44%, and the new Hazardous and Noxious Substances Convention, only 13%. So there are still potential for conflicts. Also, there are jurisdictions out there that don't sign up to anything. In this area, mainly the United States and South Africa haven't signed any of the major conventions. The other thing is that you might sign up to the convention, but when you implement it locally, there may be differences. So for example, in New Zealand, we are a signatory to the Limitation of Liability for Maritime Claims Convention, but we thought we'd be clever and redraft it, and we've only taken up half of the convention. We forgot the bit about the fund. So in New Zealand, you can get a limitation of liability decree, but you can't be forced to constitute a fund. So bad drafting can make a big difference in domestic legal systems. And I think a major one is differences in evidence and particularly allocation of liability. Let's face it, in most collisions, both ships are to blame to some extent. And the question is just what percentage you're going to put onto it. Now, different states have different rules, and the United States in particular is out of kilter with the rest of the world. They have different rules on allocation of liability. So, let's finish up by looking at the governing laws. And again, this takes us back to why there are certain fora which we regard as natural fora. If we look at A, that's where the collision happened in Hong Kong. It's essentially treated as a local tort because the Lex Fori and the Lex Loci Delicti will both be Hong Kong law. So it really simplifies matters. If you're hearing it anywhere else, you've got to split Lex Loci and Lex Fori. Now, as I say, that may not be a problem, but in conflicts terms, what that means is you have to get evidence of foreign law. So you have to pay your experts, there are difficulties with language, it adds to the expense and the time. Much simpler to deal with it where it happens. Scenario B, you've got no Lex Loci Delicti, so it's anybody's guess. C, obviously, the PRC would be the place to go because it would be dealt with internally. And D. Right, I think I'm already over